Alia Digitisation and Digital Preservation webinar titled Should You, May You, Can You, where we will briefly cover some practical issues regarding copyright and donor agreements in the context of digitising and making digitised content publicly available. So the title of this webinar comes from a 2013 article by US librarian and preservationist Janet Gertz. Today's webinar is presented by Catherine Manning, the Local History Officer at Payinthi, also known as the City of Prospect Library, located in metropolitan Adelaide in South Australia. Catherine previously held roles at the History Trust of South Australia, where she advised community GLAM groups holding heritage collections about best practice approaches to collection, management and digitisation practices. We are, I feel, very fortunate that Catherine accepted the invitation to speak with us today, as she has straddled the GLAM digitising space as an advisor, curator and collection manager, which I think brings a richness of insights and perspectives we can all learn and benefit from. So during the webinar, please post your questions in the chat and Kerry will monitor these and we will address the questions at the end. So on that note, welcome and over to you, Catherine.
Thank you, Annette, for that very generous introduction. Hopefully you can all see my little screen there now. So as Annette said, I'm currently working at Payinthi, or City of Prospect. Just have some issues getting my slides to go forward. And so I am broadcasting also from the lands of the Kaurna people today. And I'd like to pay my respects to elders past, present and emerging, and acknowledge that cultural heritage and relationship with the land continues. It's been my privilege to live and work on Kaurna land for most of my adult life. It worked much more smoothly when I tested this. So what can we digitize, or what may we digitize? And what does copyright have to do with our digitization programs? Let's go there. That's where we want to start. Copyright and collecting. Why do we care? We should care because copyrights have a lot to do with how our collections can be used. And that is something that we should be thinking about from the point of donation, offer, or any other form of acquisition, if not before. I'll detour at this early point to say something that I hope is fairly obvious after Annette's introduction, which is that I am talking here about archival, local history, and specific GLAM collections generally, and not our library lending collections that some of us may work with as well. The GLAM collection, the GLAM sector rather, can claim some exemptions for use of copyright, particularly when it comes to research, pure research, and to exhibition display. However, those considerations are quite different as soon as we start talking about digitized collections, because any form of sharing digitized collections online is considered publication under Australian law. So if we're wanting to use our digitized collections, we have to be aware of that. And while copyright law may be broken every day, potentially even every minute on social media, as collecting organisations, we don't really want to be seen as openly flouting copyright law, or at least not unless we've done an actual risk assessment, we've considered the advantages and the disadvantages of what we're doing by breaking that law, and we're confident that the advantages outweigh everything else and align with our organisational priorities. So back again to the slide that I was looking at for what may we digitise. From the point of considering our items for collection, we should be thinking about what we can digitise, both in terms of copyright and in terms of other questions. So if we can't use our collections or our intended audience can't access them, why are we keeping them, would be my question there. Of course, there are other ways that people can access our collections and there are other uses for them, but we need to be aware of those restrictions as we start thinking about what we're taking in. And we also, at times, need to be armed with the information and policies needed to defend a decision not to digitise every item in the collection when management or other keen stakeholders get excited about the possibilities once they discover what we're doing. Digitisation can, of course, be for a variety of reasons. As I already mentioned, research access. Digitisation can be for preservation, and it can be for publication. It's the last of these that copyright most impacts on, but it's also worth noting that there are other considerations when we're planning digitisation. There may be ethical concerns around access and use of items, particularly in relation to material with First Nations content. So, for example, if we have a photo featuring Aboriginal people, and it's a photo that depicts something that only men from that particular community should be allowed to see, then how are we storing that or sharing that with people who need to access it in a way that means that a white female archivist can't accidentally access that picture as well? It's not impossible, but we may need to be taking extra consideration and care when we're developing our procedures and writing them to make sure that we don't accidentally cause harm. Another consideration is privacy laws, which may apply to material even when copyright does not. I've found many items, as I'm getting to know the Prospect Local History Collection, that include full contact details. And that's sometimes for people that may be living at that address still, or at least discoverable within the community. So while versions of those documents may be of use to local history researchers, they're not necessarily something that we want to have broadly available out there on the public web for everyone to see. Of course, Annette touched briefly on the fact that there may be cost considerations for digitisation, particularly when we start talking about preservation. If preservation is to be done properly, it must follow archival standards of image size, of image quality, and for our storage backup. I frequently have volunteers and other history enthusiasts say something along the lines of, can't we just put it in the cloud to me? And once we're talking about preservation standard files, they rapidly outstrip any free cloud storage that we might be able to access, or even any cheap storage that we may be able to access. So licenses and fees need to be structured into our ongoing budget if any preservation is to take place. Is it preservation at all if it's not ongoing? Without this, we run the risk of losing our digitized collection or of having its quality rather compromised beyond usefulness. And I have heard some scary stories there. The cloud is also not as airy as it sounds either. Your cloud is sitting in a room, possibly in China or some other faraway country, on a computer server, which is doing the work of keeping your cloud afloat. Do you know where it really is? And what happens if natural disaster, political unrest, or some other major world event impacts on our cloud? Does it have the backup links in place that it will need to ensure that it does not just evaporate? Another consideration is whether items in our collection are actually worth the time and resources needed for digitisation. I've deliberately included a newspaper clipping here, bane of my life. It can be very tempting, particularly in small organisations heavily reliant on volunteers, to just get started and scan everything in sight. Some items, however, while potentially of research value to a niche community, are not necessarily going to pull in the crowds online or otherwise. And so unless there's an access request from someone who can't make it physically to see our collection, there might not be much point in sharing it online other than providing perhaps basic catalogue details to let people know what we have. So when we're at the point of thinking about what we do accept into our collection and writing our collections management for this, some specialist knowledge or research skills can be invaluable in terms of determining what fits in our collection, what's actually of use to the people who are going to be using it. As a curator at the Migration Museum, I got very good at recognising photos from the State Library collection that had been copied and reprinted by enthusiastic people who then proudly presented it to the organisation next door as something that we should take into our collection. And as a curator with what I felt at the time was limited resources to catalogue and store those items, I didn't want to be replicating what people could easily find on the excellent State Library catalogue online, nor spending the money on digital storage space for something that was being preserved properly in specialist preservation equipment and software at the State Library. So before we go into some of the specifics around copyright and licensing and how that may feed in, just a quick overview of collections management policies and what we're thinking about when we do them, or at least what I hope we're all thinking about when we put them together. Our collections management policy doesn't stand alone, which is an obvious statement, but often we write these things in isolation from each other. And in practice, our collecting work is not in isolation. So our organisation's mission statement or our strategic plan or whatever the overarching document that we have that's informing our decisions and our day-to-day work or the direction that our organisation's going in should be the overarching document that our collections management sits under and at least speaks to, if not is informed by. So in this, the dot points I'll very quickly go through. We'll be thinking about the purpose and scope of our collection in how it slots into the purpose and scope of our organisation. So my collecting area, for example, would be very different back at the Migration Museum when I'm thinking about statewide migration to South Australia and the stories that tells, to where I'm thinking about local history at Prospect. And while something might be extremely significant historically, if it doesn't have a direct Prospect local connection, there's no point in me collecting it at the moment in the role that I currently hold. And what we collect may also be about what we're physically capable of looking after or what we have decided is our remit when we've established the collection as well. So a library that establishes a photographic archive is not going to be collecting the same things as the Embroiderers Guild of South Australia, who obviously have an extensive research library, but the materials in it are of a very different format to that of another collecting organisation. Acquisition in that dot point for most of us means donation, and we'll talk a little bit about donation forms coming up. But if you're lucky enough to have an acquisition budget, then it might be something that you also have to spell out in your collections management policy and your documentation around what you spend money on, whether there are limits, and what then happens with those materials. We might have legal and ethical obligations. We might be required to collect certain things, which particularly applies for some government organisations that are legally required to store certain things for their constituents. But the ethical obligations can impact on all of us in terms of what we keep and who's able to access it, and some of those examples we talked about earlier. I'll skim through the rest because I do tend to ramble on about them, but documentation and record keeping extremely important, particularly as someone who's recently entered a new role and inherited someone else's records, which had been moved in terms of physical movement and also digital management movement before I got there. And so things weren't quite as they had left them. Storage and conservation, we've talked about a little bit already and will more. Related procedures. So this is where we get down to all of the documents that sit within your collections management policy or actually inform the practicalities of how do we apply that collection management policy. It could be things like loan paperwork. It could be digitisation procedures and your digital access plan that feeds into things. Also the donation form, which we talked about. And we don't always like to think about it, but deaccessioning and disposal, does our donation form explicitly say that this is something that might happen in the future? Do we actually allow for that to happen? And if so, is there a process that makes sure that we're not just throwing things out because we don't like it anymore, and that it has a reason that it doesn't belong in our collection anymore, and who has the power to do that? Often in organisations, it's not necessarily the collection manager. Also access, which we'll talk about towards the end and which I think we all understand fairly well, or most people seem to be very keen on, and the worst case scenario, winding up procedures. So we have to allow, of course, for if our organisation folds or just for some good reason decides that it's not our role to manage a collection anymore. So what happens to that collection then? Do we have an obligation, if we've offered to store these things in perpetuity, to then make sure that they're stored somewhere else by someone else? And that does include our digital files. So all of those dot points apply in one way or another to a digital collection, not just a physical collection. We could run a whole other session just focusing on going through those sorts of details, but I'm not going to take too much more time on that except to point at my sources, which I've listed there and which we can provide later. The first is the Help Hub on the History Trust of South Australia's website, and it gives some very broad overviews and some links off to other resources, which also includes a separate digitising collections website, which, full disclosure, I worked on setting up before leaving, but I've left that in other people's hands. And then the second site is a collections management policy template that can be found on the Museums and Galleries Queensland website. And I know libraries and archives and museums and galleries sometimes operate quite separately or differently, But I think the museums and galleries templates are really quite useful when we're talking about small organisations' archives, because they often play a role in going out and providing support to those small organisations. And this particular template is a really great comprehensive starting point for anyone who's looking to cover all bases in a collection that covers ephemera and things like that. And needs a really structured, detailed template to slot their own organisational structures into. So back to copyright, which is one of the main focuses of this talk. And so when we think about all of the things that I've just rattled through, a working knowledge on how copyright and licensing feeds into our policies and procedures should be front of mind. It's always worth remembering, first and foremost, that the owner of the item that they're donating to, and here we are focusing on donations, is not necessarily the owner of the copyright of that item. Same applies if we are purchasing it from someone sometimes. So for this reason, if the owner of the physical item and the owner of the copyright are different, separate paperwork might be needed, or we might need supplementary information in our record keeping to deal with this. At its simplest level, copyright is held by the creator of a work. So where it becomes more complex under Australian law is, for example, where there are multiple creators. In an example of that is if we're talking about audiovisual material, often there's more than one person involved in creating that. A film, which might include soundtracks, it might include different actors, might include different writers. Another example is if a creator is commissioned to undertake work. So often government organisations hold copyright for any work that they've paid for, essentially, unless there's another contract in place specifying otherwise, or there's a subcontract in place. Another example is where a creator is unknown or no longer alive. And so we'll talk a little bit more about that in just a minute. I'm not going to talk at all today unless we touch on it in the questions, and I wouldn't claim to be an expert about AI or non-human generated content. It's a whole other mess that I don't really have time for in this webinar. But some basics when we're thinking about what we might have in our collections under Australian copyright law, and forgive me for those of you who are across it already, but just rushing through. Photos, which a lot of us are interested in getting online, published in Australia before 1st of January 1955 are all public domain, so they're out of copyright, they're free to use. Most published material remains in copyright until 70 years after the death of the creator, and that spans across a lot of different material. There are some exceptions. Unpublished material since the Cooking for Copyright campaign has become, in 2017, very similar, and so 70 years after the death of the creator, and we can talk more about that later. Orphan works are the exception, and that's where we need to think about our risks and how we're managing them, in that orphan works where we haven't been able to establish a copyright holder don't have any special exemption under Australian law. And so we would need to be thinking very carefully about where and how we publish them and what sorts of conditions we put on that. And note that all through this, I've been saying Australian copyright law. So material created in other countries or shared in forums which are accessible to other countries may be subject to different laws. I've got the little logo and website here for the Australian Copyright Council because they are the resource in Australia if you want to know anything. There are a whole heap of fact sheets on their website, many of them specific to GLAM organisations, and they do run regular training sessions specifically for GLAM organisations as well. I did one of their in-person workshops many moons ago, and they run regular online workshops now since the COVID era. So once we've had a look at copyright law, if we're confident that something is still in copyright and we have been able to establish who the copyright owner is, the Creative Commons licensing is one of the most common forms of licensing that is easy to apply and that many GLAM organisations have started to use in the last few years. So it's something to think about writing into your paperwork and referring to in your procedures. The Creative Commons is something that's used globally. That's the Australian website that I've included here on this slide. And if you can see that image, I'm not sure how clearly it will show up on everyone's screens. It's really just demonstrating that the Creative Commons licenses operate on a sliding scale. So if something's under full copyright, which is not one of the graphics from their licenses, and the creator hasn't released it under license, then control is maintained completely by them. And the Creative Commons licenses operate from a full control still, but with attribution and permission to use with that attribution, through to a completely free use without necessarily restricting anything. You might have seen at the bottom of some of the images I had earlier in the slides, the CC0. That's not shown in this image, but that means that the organization or the person who maintains copyright hasn't even required you to attribute that image or work to them. So the terms here confuse some people, but really the CC is the license name. The BY is attribution. That means that you're crediting the work back to where you found it. And that work may be an image, it may be something else. And then the other letters that come after it and the other symbols are really just I can't say that's today, sorry. They're specifying particular restrictions that the owner of copyright has asked, and in some cases has asked other people who use the image to pass on. We can talk through this more in the questions if people have specific questions. But I'd encourage you to go to the website and have a really good read through the explanations. It's very clear and they make it very easy to use all of the licenses that they have there. Coming back to donation forms in tandem with our collection policies, they of course are a key component of our procedural paperwork if we're not acquiring items or even if we are buying them as well. They should cover the legal transfer of ownership of the physical item, as I mentioned earlier. So if we're going to deal with copyright in our donation forms, it must be clear who owns that copyright and whether it is in fact the donor, in which case they can sign off on it, or whether separate paperwork is going to be needed and that's happening. You may, I'm sure we all have, inherit imperfect paperwork where that's not clear. And I have seen donation forms where someone who's clearly not the copyright holder and easily established as not the copyright holder has signed off on copyright transfer. And obviously that doesn't hold water if you're actually then going to turn around and use the objects in your collection, and that's happened. So it's not the end of the world, though. I don't think we should abandon all hope and stop using things. I think just that it's worth noting, it's worth making sure that when we review our collections management policies and procedures, we allow for that. And we have paperwork or records in place in our collections management that make clear what we're doing to address that. So it helps in our cataloguing if we're making clear who the creator of an item is. And if we're publishing online through larger organisations or platforms, that's often something that they're asking for anyway. It's something that's included in things like the Dublin Core standards of data that we include with our collections records. So if we're doing the work and making sure that we understand who is the creator, that they are the copyright holder, that they haven't done it under contract for someone else, or that copyright hasn't already been signed over to someone else, we're then able to approach the copyright holder separately and have them sign off on perhaps a digital asset release form or something similar where we use those Creative Commons licenses or we ask for some handover of copyright. I would say that people are generally more happy to hand over permission and have something in place where they can be contacted and they know what's happening with their things than just handing over copyright wholly and solely, but that's not always the case. Some people are very generous. So as long as we're making an effort and we're putting that information on paper, most organisations are moving forward with sharing digital collections and sharing them online. This documentation is really important in terms of making sure that we're protecting ourselves and our organisations, but also just in terms of good collections management, in terms of making sure we understand what our collection is and where it's come from. So when we're doing that, we should be thinking about things like, do we have standards around what is a reasonable attempt to establish copyright and how we're documenting that? It can be as simple as saving the information that we have found in the collections database or in our spreadsheets or our object files or whatever it is that we have in relation to our collection. But if we're drawing a blank, there should be some way of documenting the fact that there's been an effort made. And somewhere in our digital access plan or our collections management paperwork, we would want to be thinking about what constitutes a reasonable attempt to establish copyright. In best case scenario, putting that in writing so that it's a very clear process to follow. It's also a very good idea to have a takedown procedure for what happens when someone gets in touch and says something like, well, actually, my mother took that photo. My cousin might have given it to you, but she didn't inherit the estate, and the estate's still in copyright. So we have to be thinking about what happens if all our good intents go awry. And I've got another couple of links here just with examples of donor forms that people have put together and how they're putting together if people want resources that they can go to look at how that's incorporated. The exciting bit, of course, is that eventually we get to the point where we can share collections online. And that's something that at Prospect I'm still working towards. But it's something that previously I've had a lot to do with at the History Trust and with other organisations. I thought about sharing one of those here, but I've got a screen grab from the Flickr site of the City of Port Adelaide Enfield, which I should note is potentially breaching Flickr's copyright, even if I have got permission from Port Adelaide Enfield to share it. They were very kind. But it's just here as a reminder, both to myself and everyone in the webinar today, that we don't necessarily have to have our fancy digital asset management systems or websites run by a team of IT professionals to make at least highlights of our collection available online. It's worth taking note of organisations like City of Port Adelaide Enfield Libraries, because they have been doing digitisation well for decades. And if we're just getting started or we're reviewing where we're at and what resources we have and we can't do the fancy website, it can be incredibly useful to tap into staff who have worked through those issues before or who are doing it daily. In South Australia, where I'm sitting, the History Trust of South Australia has a network under museums and collections where a lot of people have done really creative things on a very slim budget in very small organisations. And so they're a really useful resource to tap into, as are the History Trust staff and the staff at the State Library who are working on digitisation plans with some of the smaller libraries. Apart from drawing on ALIA networks interstate too, there's the Australian Museums and Galleries Associations that I mentioned before, who often offer training and resources and templates and planning for smaller organisations that they work with. Of course, there's always Google, and there are huge numbers of resources and templates online in terms of planning your collections management policy and your digital asset forms and things like that. My only words of caution would be to keep in mind that international laws are different when it comes to copyright and to access for some of those digital assets. And so some of those laws referred to in international templates won't apply here in Australia, and it's best to consult a local expert when in doubt on those. So just to summarise, our policies and procedures are there to guide us in how we shape our collections and ultimately how we use them, which should be part of how we shape them. So if we don't understand all the implications of how people are accessing our collections, then we can be left scrambling to justify what we have in our collection, how we're using it, and how we're not using it sometimes. Our decisions about digitisation shouldn't be confined to a digitisation policy in isolation from our collections management practice. Too often, as I said before, our policies and procedures take place in silos, while our collections management practices naturally impact across all the different areas. So my takeaways would be to make sure that our policies and procedures are up to date and to look at them with a critical eye, considering access as well as digitisation and all the other implications that has. And we need a working knowledge of things like copyright and licensing if we're to do that. We should know our organisation's priorities. If our organisation is not keen on having the whole collection up online or accessible in a digital format, then it might be something that actually doesn't come into the collections management in a big way, or is mentioned as something that's a lower priority or not there for the resources. But if it is, then we should be planning for it. We also need to be aware of the risks. I did touch on it briefly, but I think I sort of strayed from my prepared script in terms of orphan works and thinking about risk management if something is unknown copyright wise, but potentially within copyright, and we haven't been able to establish the owner, then it doesn't mean we can't use it, but we do have to think carefully about it. So I will leave it at that point to hand over for questions. And back to you, Annette.
Excellent. Thanks, Catherine, for that very informative session. Now, there aren't any questions in the chat, but I know, Kerry, you've got a couple. If you would like to
Yep,
ask them.
I do have a couple. So, one of our questions is, when looking to digitize collections and make them available publicly where copyright or provenance is not clear, could it be useful to consider a risk management framework to assess the risk about making it available publicly?
Absolutely is the short answer. The longer one is that if people are familiar with their organisational health and safety procedures, then you might know that often in the occupational health and safety world, they have a risk matrix, and there's the difference between the disaster. No, is it the risk and the I'm forgetting the health and safety terminology, but basically things work on a scale. What is the likelihood of that happening? What is the expected problem if it does happen? So the harm to a person or the harm to equipment, in the case of health and safety, usually the person. And so you assess things on that sliding scale, and it will usually be on an axis against each other. So the same sort of thing could be very useful for your collections management and your publication online. Online publication is great in that it can be taken down very quickly, if that's the best course of action, whereas sticking things up on a wall, and I said right at the beginning that there are exemptions for GLAM organisations in exhibitions. That's if you've got the original material. Reproducing it and sticking it on the wall is still considered publication, and that's still a breach of copyright. So if I have, for example, the Prospect Local History Collection has a really sensational collection of local community artworks produced sometimes by some quite famous people. If I reproduce that artwork and stick it on the wall, I have broken the artist's copyright by reproducing it. But if I've got licensing, release, and permission from the artist, that's different. It is harder to take it down from the wall than it is to take it down from a website or from a social media post. Although, as we all know, there can be ongoing repercussions from that publication online. Once it's out there, other people have the ability to copy it, whether or not you've put up the licensing terms or not, and they may not follow the law. As long as you have followed the law on behalf of your organisation, you've met your obligations usually. So yes, is the short answer to that. A risk matrix can be very helpful. And you would be thinking there about things like, how likely are they to sue? Disney, Sony, highly likely. If it's not Disney and Sony and it's someone's happy snap from Auntie Jan's birthday party that they've shared with the local history collection, they're probably not going to want to take you to court for a packet, but they might be upset and it might damage your organisation's relations in the community. So it's a consideration about, well, can you manage that in other ways? And can you make sure that you minimise that damage if someone does get upset? So yes.
So Rebecca's got a question. Is an organisation the same as an individual when it comes to copyright?
I'm not an expert in terms of all of the copyright laws. That's one that you could put to the Copyright Council. They have a free service of question and answer for people working in GLAM institutions. But to my knowledge, to a certain extent, yes, in that if I put something online on behalf of the City of Prospect, it is the City of Prospect that's going to be taken to task for breaking the copyright laws. And ultimately that would stop with our CEO and our council, who would be incredibly unhappy with me. There would probably be repercussions for me as a result of that as an individual. But the way an organisation and an individual operates under law in terms of being taken to court and how that impacts. I don't know enough detail to go into all of that, but essentially an organisation can be seen to break copyright law as much as an individual can. But then how that's dealt with and plays out, I would need to consult with a copyright lawyer to give you the fine detail on that. That there are repercussions for both is all I would say.
Excellent. So our next question is comes from the Melbourne Holocaust Museum. We have a lot of government documents, example passports and landing permits in our collection. Does government or the individual hold the copyright on this?
Governments usually do, and sometimes the law is different for them. On the plus side, and I don't know in the case of the government there exactly what's been decided, but I know that the South Australian government made a decision a while ago to release government copyright material, or a lot of it, as freely as possible. So a lot of South Australian government material is released under a CC0 license, which is no restrictions, no attribution needed. I would check that the government organisation that created it has actually something specific in place, because regardless of how broadly some governments decide that they would like all of their departments to act, sometimes departments do things individually regardless, and it is generally the government department that's created it that would be the main point of contact. I know when I first started work at the Migration Museum, which had been set up in the 80s, and I started in the early 2000s, I got told by the then director that there was a signed letter from the Department of Immigration releasing a whole heap of photos to us to use. I never managed to put my hands on the signed letter, but because she was the director and willing to take the fall if anything happened when those photos went public, we did tend to use them, and credit the department changed its name so many times. Credit whichever the department was called at the time that we used it. And they were all government publicity photos, you know, showing happy migrants post-World War II. Generally they were things that we didn't think there was a huge amount of risk attached to either. And I probably, while I think risk matrices are great, and we should document as much as possible, particularly if we're trying to leave our collections in good shape for people coming in, I probably am a lot more lax in terms of following through practically sometimes myself in day-to-day work, in that as long as a donor understands the form and signs the form, I will still let them stipulate that they want to be credited as the donor. I will document attempts to track down copyright, but as long as I've got management in place, understanding what's happening and willing to take a risk, when it's something that is low risk and easy to deal with, should something terrible happen, I'm pretty relaxed about putting things out there compared to a few people that I've worked with. We were chatting before the webinar started about you know, what we do in our own practices, particularly in our personal archives, versus what we do at work, and there can be a world of difference.
I do know from personal experience, the New South Wales state records have embargoes on certain records for certain periods of time. And then I know personally from my collection, I've digitized enrollment forms, the enrollment book for one of the famous high schools here. And I felt that when it got to the late 1970s, I chose not to put those online because of the amount of details, as in parents' names, date of birth, parents' occupations, telephone numbers, phone numbers. I was worried about identity theft. So I think regardless of all the copyright rules, sometimes you just have to go, you know what? I really don't think that belongs online. So
And that
that
comes back to our earlier conversation about privacy laws being different to copyright laws. Sometimes those do cover it. And sometimes, as you say, it's an ethical decision. It's people don't need this information badly enough to put at risk someone who might face harm because that information has been put out there. And so, yeah, I think in archives in particular, but also in some of our community library collections, there are a lot of really personal details that don't necessarily belong up there for everyone to find. But they may also, there's a lot of historical house research going on in Prospect amongst the local history group. And so some of that information may be of use to them. It's just in terms of how they then turn around and use that. Does it get published in a book that reveals, the house owner's name and other personal details, or is it purely about tracing what's happened with that house? And so I think, yeah, it is often an ethical decision rather than a legal decision that we make. And that's where I think good documentation is crucial, in that if you're clear about what your organization's stance is in terms of what's acceptable ethically to share and what's not, and there are parameters placed on that, then it's a very safe environment to operate under in terms of how we share. But if we're not clear on it, we tend to be more cautious, because if you're not confident of what the outcomes or what the repercussions might be, then caution is the best way forward.
Yeah, so if you're in New South Wales, check out the New South Wales State Records Act, and that gives you lots of provisos for embargo times and things like that. So, and I'm sure the other states have something similar. So our next question was from Natasha. Can you suggest a framework or guidelines for what constitutes a reasonable attempt to establish copyright?
I deliberately didn't put one in. But there is one, and I'm relatively new to libraries, having come from museums. There is a National Libraries statement, which is the name of which is escaping me right now, in terms of the standards of establishing copyright ownership. And I think it's a fact sheet put out about orphan works as well, that talks to it from the Australian Copyright Council. I'm going to cover complete blank on the name. Sorry, I'll see if I can find it again and provide it to the ALIA organisers when we distribute links and other information. But certainly different organisations do it differently. I would think that, having just Googled them is potentially not enough. And that you'd want to make attempts to get in contact with people related to the creation of the material one way or another. So document emails sent, or document what you have been able to establish in terms of what you know about the material. I have seen material put up with very little attempt made, and just copy and paste standard statement that's been used by a state library or other larger organisation, change the name. It does happen. And again, it's that there's often not a lot of fallout from that. But I think if we're again going back to ethics, if we're doing what we believe to be right as collections managers and doing our due diligence, I would expect that most of us would want a little bit more than that. And it's only when you really hit the brick wall that you would turn around. So I don't have a specific framework to point to right now, but I would say have a look at what it's taken for one of your harder, challenging pieces and how many attempts you've made with that, and then see if you can write that into a broad framework. It's like, X attempts to contact someone, or research that's taken X amount of time and drawn on specific sources, if we can document them. But it's how long is a piece of string? It is actually really hard sometimes, because I have inherited some things in collections where it seems fairly reasonable to assume that a staff member or someone paid by the government organisation has taken that photo for promotional reasons. Is that enough for me to then turn around and say it's copyright to the organisation? Probably not. Is it enough for me to turn around and use it online with we think this is fairly safe? Maybe, if I've been able to establish that it was taken for the organisation and hopefully who it's by, that sort of thing, I would think about it. yeah. How long is a piece of string is where I'll go with that one.
And I'll just skip down to another question which follows on from that, which would be, would you be adding this information to the catalogue records for the items?
Absolutely. Yeah.
Um,
I have had experience a few times now where I've been in organizations where the collections manager I know has been very thorough and documented things and kept great records, but for one reason or another, those records have not been accessible to me. So the more places you can put it and the closer to the ultimate catalogue record that you are confident is always going to be there in some form remains, the better. And I've had to question my own theory about, you don't need to keep everything physically if you're digitizing the information that goes in the background, because it has saved me several times that someone has kept a whole bunch of stuff that I don't think is collection proper in with the collection. And that's been the only place I've been able to find it. So it's a balance, and it's about making sure that there are procedures and processes that people beyond our own remit in the organisation understand, and that material will survive with the documentation. But yes, I would absolutely put that information somewhere in the catalogue record.
Okay, so our next question is from Marissa, and any special considerations in policy guidelines required for the digital images of children and adolescents?
It depends. And this is where privacy laws might come into it. I mean, we all know that, well, hopefully we all know that when we've got a school group coming in current day, we need to sign off some permissions before anything's done with that. However, if there are photos taken of children at a public event out of uniform, there's actually no specific restriction on using them. You can do it with just a verbal nod. Most PR, marketing, communications teams would have more than that in place just to protect themselves. But that is about people currently and their privacy currently. So, and this goes back to the embargo laws that you mentioned, Kerry, that organisations, particularly government organisations, do tend to make a judgment about what's a safe time for that sort of personal information to be released. And it's a bit the same with images. The law does tend to make a judgment about what's a safe amount of time. So it will depend on the context of that photo and whether it's, I would err on the side of potentially getting permissions if that person is still underage and not able to sign off permission themselves, then permission of a guardian is probably needed. If that person is old enough now to sign off themselves, and you're able to track them down, then absolutely that's a useful thing to do. It would be, again, a bit of a risk assessment, I think, if you couldn't track them down and you didn't know where they were. And it would depend on context and how it's being used, what the risk of harm to that person in the picture is if you do use it in some way. So again, it's the sort of thing where it would be something that a risk matrix might work, or what some of us would refer to as common sense, which is not so common in terms of having a think through, do we think this is a good idea, essentially, and so I can think of examples where, if there's trauma or abuse or other particularly difficult issues involved where it might be a very bad idea for that image to be out there, and we don't necessarily know that. So its context is key in that point, and doing the best that we can with the information we have.
Okay, that's all the questions that we have at the moment.
So, well, and just thank you, Catherine, for an informative presentation, and thank you for those very insightful questions. And that last question was a wonderful sort of segue into our next webinar scheduled for August the 6th, which is on the topic of cultural awareness and sensitivities in digital collections. So that was a perfect note to end on, actually. So that's scheduled for Wednesday, the 6th of August at 1 p.m. Australian Eastern Time. And also just to say that ALIA does have a copyright training micro credential. If you feel you would like more guided learning on this topic, because this is just a high level overview, and we've really enjoyed the benefit of Catherine's knowledge in this space, which you've answered some very tricky questions very, very well. Thank you. So we'll wrap up now, and we look forward to seeing you in August. Okay, so thank you very much and take care till then.